Yeah, 167. Yeah. No, that's the part that needs to be deleted.
Right. Did you mention to the lawyer about this case?
I did not.
On page 3, the victim impact paragraph has superfluous clause on the end related to the death penalty. And finding that the aggravating circumstances cannot outweigh the finding of one or more mitigating beyond a reasonable doubt. We've taken that out of there. So it just says if you find that the existence of one or more aggravating circumstances improved beyond a reasonable doubt by evidence independent from the victim's impact. So that clause is out of there because it really applies to the standard for the death penalty, not life without parole. Okay, we ready for the jury?
Yes, sir.
Thanks, ready, man.
Okay.
Ready.
Okay, members of the jury, you've heard the evidence on the issue of sentencing and now the closing arguments of the attorneys on that issue.
There's no doubt in my mind that Ms. Thomas is a good woman, a woman who worked hard, 2 jobs, raising Mr. Thomas along with other kids. There's no doubt in my mind that she instilled in her kids, including Mr. Thomas, values. That is values to respect life, to respect other people, to work hard, to do right. But unfortunately, ladies and gentlemen, those values that she instilled in her son are not the values that he followed, that he held true to the first weekend of January 2007. That George Thomas was a different person than the man she raised. George Thomas had become a man who would rather stay in a house filled with criminal activity, hanging around criminals, who possessed guns, who sold dope, who would victimize, put their hands on, stick a gun in the faces of women. That was his choice. He chose to stay in that household. He chose to stay around those folks. Instead of going back to Kentucky and maybe starting over, working hard at a legitimate job. That was the Mr. Thomas who chose to stay in that house, the house that is smaller than this courtroom, and listen to the cries of Shannon Christian as she's crying out in pain from being tortured, from being raped vaginally, orally, and anally. Didn't hear the cries of Mr. Newsom since he had a sock in his mouth. He stood there and watched as Mr. Davidson pulled the trash bags out of the box. And did nothing. The values that his mama taught him did not matter to him that first week. Just as Shannon Christian cried out in pain, this crime cries out for justice. And there are certain crimes that are committed that deserve the jury to tell a defendant, you, sir, because of the crimes you committed, because of your conduct, you don't deserve to walk on the streets again. And that is this crime. This crime that the defendant committed. It's not the death penalty. It's not being locked away in a dungeon someplace. Now, visitation in the penitentiary, phone calls, letters. But Mr. Thomas, his conduct justifies him getting a sentence of life without the possibility of parole, for him being locked away for the rest of his life. And we ask that not because of emotions. We're not trying to play on your emotions, but we're asking to do that because of the law. And it's because of those 7 enhanced aggravating circumstances that we talked about in opening. The 3 for Ms. Christian and the 4 for Mr. Nixon. We believe that the proof from the witness stand at trial has established those 7 beyond a reasonable doubt. There has been absolutely no proof introduced to rebut those 7 aggravating circumstances. And because we follow the law, because we believe we've established that, that is why we're asking you to sentence Mr. George Giovanni Thomas to penitentiary for life without the possibility of parole. Thank you.
Ladies and gentlemen, it's been difficult on everybody, especially on you all, to have been here, to listen to all the proof in the guilt phase, to see pictures, to hear the testimony. It's been total, I'm sure, on each one of you. But we're in the sentencing phase now. Something the state doesn't seem to realize, that we're no longer talking about criminal responsibility. Argument of the state during the guilt phase was that Mr. Thomas associated himself with the case. There's no proof that he did personally anything to Shannon Christian or the prisoners. There was no proof that, as the state said, that he stood there and watched as Davidson pulled out these trash bags. There's no proof of that. None whatsoever. And what we're asking you to do, ladies and gentlemen, as Mr. Johnson said in the opening statement, is understand, first of all, the difference between life and what we call life without parole. As he said, it's a misnomer. There are only 2 choices now. And that is life without parole or life with no opportunity, no chance for release. Really, a life sentence now. You don't get parole. There's no chance for parole. How they calculate it is 100% of 60 years less 15% for basically good time. So if you're a model prisoner, you don't spend 60 years, you spend 51. That's it. That's the floor. You cannot get out before then alive. So we really have 2 choices. 51 years or basically life with no possibility of release. Now, in the guilt phase, criminal responsibility for the conduct of another was the hallmark, the benchmark of the state's case. Criminal responsibility for the conduct of another does not apply in this particular sentencing phase. It does not apply to the sentencing phase. As the court will charge, the law is, the law of criminal responsibility does not apply at the sentencing phase of the trial. Rather, sentencing is an individual decision about the punishment of the defendant. And there are several mitigating factors that you are allowed to consider that we have noted and that the court was charging. And I'll just name a couple of these. One of those is that Mr. Thomas was convicted as an accomplice in the murders committed by other persons. We know who committed the murders. It was not George Thomas who actually committed the murders. There was no proof of that. Mr. Thomas has, another one is that Mr. Thomas has no significant history of prior criminal activity. You can consider that. There's been no evidence of any prior criminal activity. The youth of Mr. Thomas at the time. We know that he was 24 at the time of these offenses. And certainly the effect that you will also be instructed on, the effect that no possibility of release, even if Mr. Thomas is elderly, would have on his family. And certainly Bridget Thomas and the rest of the Thomas family would have an effect on us to know that Mr. Thomas, her son, their brother, their cousin, would never get out, as opposed to him getting out at the earliest in 51 years. And believe me, ladies and gentlemen, maximum security in a Tennessee Department of Correction facility is not a country club. He was not directly involved as a principal actor in these offenses. And that's another element, that's another mitigating circumstance you will be charged. So the bottom line is, ladies and gentlemen, at this point, there's not very much difference. Let's face it. He will spend 51 years in prison. 51 years. And as Ms. Thomas said, she'd be 100 by then. But at least she and the rest of the family will know that there's somebody, that Mr. Thomas will get out of prison. Otherwise, he's in the rest of his life. When he was convicted under the criminal responsibility statute and the theory of criminal responsibility, which doesn't apply to the sentencing proceeding. All we're asking, ladies and gentlemen, is that he be given a life sentence. And that really is life without parole. As you said, it's a misdemeanor. No chance of him getting out early. No chance of parole. It's a 60-year sentence with a maximum of 15% off. And that's it. And based on his role in these offenses, as you have determined, we think that's the appropriate sentence. And we hope you agree. Thank you.
Very briefly, I know you're all ready to get back and start deliberations and make your decision. I thank you again for your service, for your attendance throughout this week. And this is not a happy day. It's not a happy day for anybody. Come back, read that verdict, knowing what the consequences were. There's no victors in this courtroom. But there's one more decision we're going to ask you to make. And it really boils down to hope. Hope. that's been discussed here. Mr. Dillard mentioned that. Hope for Ms. Thomas. But think about the victim impact evidence you've heard. Think about all the hope that those parents had for their children, all the dreams they had, dancing out their wedding, seeing the grandkids, seeing those two beautiful young people grow up, be productive citizens. And that was all taken away. All taken away by Mr. Thomas and his compatriots. Now, yes, criminal responsibility doesn't apply in sentencing, but that doesn't mean you ignore this crime. That doesn't mean you just put that to the side and forget about the circumstances of this crime and what Shannon Christian, Chris Newsom went through. Because one of the major, the predominant factor we're asking you to look at, aggravating circumstances, the heinousness, the atrociousness of this crime. It's appalling. So when you consider it and you look at that, it outweighs any mitigating circumstances that have been suggested to you by the defense attorneys, being presented to you, and anything you might think of in addition to that. It still pales in comparison to this crime. Now, there are 3 penalties in the state of Tennessee for first-degree murder: life without parole, and the death penalty. Now, the death penalty is reserved for the worst of the worst. Somebody like the United States. And the state's not asking you to make that determination. You've got to decide between life and life without parole. And yes, it makes a difference. It makes a difference because life without parole, based on what you've seen and heard this week, is what justice requires. So when you go back to deliberate, I again urge you all to have a long week, but listen to one another, be courteous to one another, think about what is just, think about this crime, think about what Chris and Shannon went through. These parents would love to make a phone call and just talk to their children one more time. Ms. Thomas can do that the rest of her life. These families, they'll never talk to their kids again. That hope's been taken away. Justice requires life without parole. Thank you.
All right, if you distribute copies of the instructions, please. And we're going to do it the same thing, 1 copy for every 2 juries. Members of the jury, you have now found the defendant George Giovanni Thomas guilty beyond a reasonable doubt of first-degree murder of both Shannon Christian and Hugh Christopher Newsom as charged in the presentment. It is now your duty to determine within the limits prescribed by law the penalty which shall be imposed as punishment for this offense. Tennessee law provides that this defendant convicted of murder in the first degree shall be punished by imprisonment for life without possibility of parole or by imprisonment for life. A defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravating circumstances proved beyond a reasonable doubt and any mitigating circumstances which have been raised by the evidence throughout the entire course of this trial, including the guilt-finding phase or sentencing phase or both. The jury is the sole judge of the facts and of the law as it applies to the facts in the case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The law of criminal responsibility does not apply at the sentencing phase of the trial. Rather, sentencing is an individual decision about the punishment of the defendant, George Thomas. The burden of proof is upon the state to prove any statutory aggravated circumstances or circumstance beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by the law, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given to the evidence. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to show the financial, emotional, psychological, or physical effects of the victim's death on the members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant, not an emotional response to the evidence. Victim impact evidence is not the same as an aggravating circumstances. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstance which has been alleged. You may consider this victim impact evidence only if you first find the existence of one or more aggravating circumstances has been proved beyond a reasonable doubt by evidence independent from the victim impact. Statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon the unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more statutory aggravating circumstances, which shall be limited to the following. For the first-degree murder of Cannon Christian, 1. The murder was especially heinous, atrocious, or cruel, and it involved torture or serious physical abuse beyond that necessary to produce death. 2. The murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution of the defendant or another. 3. The murder was knowingly committed, solicited, directed, or aided by the defendant, while the defendant had a substantial role in committing or attempting to commit, or is fleeing after having a substantial role in committing or attempting to commit any first-degree murder of Hugh Christopher Newsom, any rape of Cannon Christian by oral penetration, any rape of Cannon Christian by vaginal penetration, any rape of Cannon Christian by anal penetration, any rape of Hugh Christopher Newsom by anal penetration, any kidnapping of Cannon Christian, any kidnapping of Hugh Christopher Newsom, any robbery of Cannon Christian, or any robbery of Hugh Christopher Newsom. For first-degree murder of Hugh Christopher Newsom, 1. The murder was especially heinous, atrocious, or cruel, and that involved torture or serious physical abuse beyond that necessary to produce death. 2. The murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution of the defendant or another. 3. The murder was knowingly committed, solicited, directed, or aided by the defendant, while the defendant had a substantial role in committing or attempting to commit, or is fleeing after having a substantial role in committing or attempting to commit any first-degree murder of Cannon Christian, any rape of Cannon Christian by oral penetration, any rape of Cannon Christian by vaginal penetration, any rape of Cannon Christian by anal penetration, any rape of Hugh Christopher Newsom by anal penetration, any kidnapping of Cannon Christian, any kidnapping of Hugh Christopher Newsom, any robbery of Cannon Christian, or any robbery of Hugh Christopher Newsom. 4. The defendant knowingly mutilated the body of the victim after death. You are instructed that the word heinous means grossly wicked, reprehensible, abominable, odious, or vile. Atrocious means extremely evil or cruel, monstrous, exceptionally bad, abominable. Cruel means disposed to inflict pain or suffering, causing suffering painful. Torture means the infliction of severe physical or mental pain upon the victim while he or she remains alive and conscious. Knowing means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravating circumstances in deciding whether imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include, but is not limited to, the following. 1. Any residual or lingering doubt as to whether George Thomas committed the charged murders. Residual doubt evidence refers to proof that the defendant did not commit the murders and that, notwithstanding the jury's verdict of guilt, may raise some lingering or residual doubt in the jury's mind about the defendant's culpability and which may act as a mitigating circumstance. 2. Mr. Thomas was convicted as an accomplice in the murders committed by other persons, and Mr. Thomas's participation was relatively minor. 3. Mr. Thomas has no significant history of prior criminal activity. 4. Mr. Thomas acted under extreme duress or under the substantial domination of other persons. 5. The youth of Mr. Thomas at the time of the crime. 6. The effect that no possibility of release, even though Mr. Thomas is elderly, will have on his family. 7. Mr. Thomas has a history of substance addiction or abuse. 8. Any mercy for Mr. Thomas as a person who is not directly involved as a principal actor in these offenses. 9. Any other relevant mitigating fact or circumstances raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing, that is, you shall consider any aspect of the defendant's character or record, or any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence. Mitigation is defined for you as that which tends to soften, temper, or make less harsh or severe. Thus, mitigating circumstances surrounding a criminal offense are those circumstances which tend to lessen the apparent badness of a particular crime in question or the apparent badness of a particular defendant. As I have previously told you, mitigating factors also include any sympathetic, compassionate, merciful, or other aspect of the defendant's background, character, record, or social, psychological, or medical history that, based upon the evidence whether or not related to this offense for which he is on trial, you must disregard any jury instruction given to you in the guilt or innocent phase of the trial which conflicts with this principle. You must consider whether there are any other facts which may be considered as extenuating or reducing the defendant's degree or more culpability for the crimes he has committed, even though such facts would not justify or excuse the offense. The defendant does not have the burden of proving a mitigating circumstance. There's no requirement of jury unanimity as to any particular mitigating circumstances or that you agree on the same mitigating circumstances. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. He's not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. First, life imprisonment. If you do not unanimously determine that a statutory aggravating circumstances has been proven by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict upon the enclosed form attached hereto and made part of this charge. The verdict shall be as follows. We, the jury, unanimously find the punishment shall be life imprisonment. Verdict. life imprisonment, or imprisonment without possibility of parole. If you unanimously determine that a statutory aggravating circumstances or circumstances has been proven by the state beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to imprisonment for life without possibility of parole or imprisonment for life. In choosing between the sentences of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory aggravating circumstances or circumstances proved by the state beyond a reasonable doubt, and any mitigating circumstance or circumstances. In your verdict, you shall reduce to writing the statutory aggravating circumstance or circumstances so fine, and you shall return your verdict upon the enclosed form attached herein and made part of this charge. The verdict should be as follows. We, the jury, unanimously find the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. You shall then list the aggravating factor or factors found beyond a reasonable doubt and indicate on the enclosed verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. The verdict must be unanimous and signed by each juror. Take the case, consider all the evidence fairly and impartially, complete one of the two forms for each offense, and report your verdicts to the court. Members of the jury, the officer will give you the forms mentioned in the charge. You may now retire and consider your verdict. Thank you. Thank you. Okay, the court will stand in recess pending a verdict on the sentence. Thank you.